CEI, FIDIC, and Asia Pacific and interact with their peers and to develop next generations of leaders.
Sure.
The main objective of this forum provide a voice of the voice for the young professional within CEI, increase number of participants in CEI young professional activities, strengthen the culture of dialogue, organize technical lectures in science, engineering, and architectures, publicize best practice and standards, share success stories about young professionals, provide a supportive space for young professionals to discuss and communicate, enhance the consulting engineering professions. Now I would like to request President Mr. R.S. Sharma to say something about CEAI. He is a civil engineer by qualifications and over the span of more than 50 years of experience and distinguished career. He has been member of Governing Council of CEI for over 12 years and served as a treasurer for 8 years. During that period, he has served on various committee and organized seminars. He is a life member of CEI and one of the pillars of the association. His outstanding contributions to the highway sector, he has been honored with the Lifetime Achievement Award by the Indian Road Congress for the year 2022. He commands considerable respect in government and consultancy and contracting industry in India. Dear sir.
Okay, thank you, Mr. Mahir. Again, on behalf of CIA, it's my duty to welcome all the speakers, then the organizers, and also the attendees who are attending this very useful webinar on legal and general aspects of contract process and contract administration. The Consulting Engineers Association of India is a apex body of consulting industry in the country. It is affiliated with the FIDIC. It was established. It has got over 60 years of working in India, and our objectives are manifold. First is to inculcate quality and ethical culture in the sector, then to improve the skill of all the professionals, right from the zero level. Say we have got the young professionals as members, we have got members from the individual members, consulting organizations, EPC members, all the private sectors who are in the consulting sector, they are our members. Even some government bodies are our members. This is the third webinar being organized by the Future Leader Forum. That is what has been introduced by Mr. Veer Singha. And it is on a very useful topic, that is on legal and general aspects of content administration. Apart from our technical designs and other supervision, content administration is also a very important field, especially for the senior persons in the organizations, say team leaders and the content managers. So all the contacts we have to manage, whether it's FIDIC contact or any legal contacts are there. So the knowledge in this field is also very necessary for all the professionals. So for this webinar, Mr. Mihir Singha will be the moderator, and I give that floor to him to start the proceedings. Thank you.
Thank you, sir. Now I am going to introduce moderator of the session, Mr. Asim Rastogi. He is a civil engineer by qualifications and over the span of more than 10 years of experience in the field of bridge and structural design. He completed his civil engineering from Allahabad in 2010 and post-graduation in MTech structure from BIT Misra Ranchi in 2013. He is a permanent member of the Institutes of Engineers and Indian Road Congress. As a structural engineer, he successfully completed many construction projects, which includes DPRs and construction projects in India and abroad. He is skilled in all phases of engineering operations and having vast experience in design of PSC, RSCC, and steel structures with shallow and deep foundations. He successfully completed the design projects in Myanmar, Tanzania, Democratic Republic of Congo, and Bangladesh. Now, request to Asim to take over this.
Thank you, Nair, for your wonderful words, and good afternoon to all of you. I again like to welcome you all for this seminar, which emphasizes on contract process and contract administration. By this, I am happy to welcome on behalf of CEAI and Future Leader Forum, Dr. Vandana Bhatt as our first presenter of today's webinar. She is a former Class 1 engineer of Government of India. She is having a brilliant academic career with ME in Construction Management from Mumbai University and MBA in Construction Law. She is a senior professional with rich experience in project administrative consultancy service in the field of construction for an ongoing claims adjustment and arbitration. A part of it, she guides PG students of IIT Bombay in construction law. She has contributed numbers of papers on construction management related to claims and co-author books titled Laws of Engineers. Besides being fellow member of Institution of Engineers and member of American Bar Association, she represents Fraternity of Engineers hosted by American Concrete Institute International Seminar on Concrete Structures at Washington. She has been presenting arbiter and co-arbiter along with former judges of high courts and eminent engineers. She has been awarded with Dadabhai Noorji International Award and Best Woman Professional of the Year 2008-2009 by FICCI. Besides this, she has been mentioned for her leadership quality in 2002, honored International Who of Professional and Businesswoman Award. She has been member of team facilitated for awards of distinction for culture heritage conversion work by UNESCO 2007. By this, I give the floor to Dr. Vandana Bhatt for his presentation and provide insight for today's topic. Thank you, ma'am. Please, now floor is yours.
Yeah, thank you very much for such a loud introduction about me. I don't know how far it is to be taken as that I'm eligible for such a loud words. But anyhow, thank you very much, sir.
Thank you. Thank you.
Now I will start with my presentation.
Yeah. Sure.
Just give me 1 minute. I'm sharing it. Because it's taking little time today. I don't know why. But anyhow, now I hope all of you can see my presentation.
Yes, it is visible.
Yes.
It is visible, no? Fine. Anyhow, good afternoon once again to everyone. At the outset, I will thank CEAI for giving me opportunity to talk to younger generation on this topic, which usually we don't learn in the college. When we are learning engineering in the college, this is not the subject which is usually taken care or given any importance to it. Of late, IIT Bombay has introduced this subject and it is being well received by all the students of IIT, which we are doing it since last 14 years, this subject. So I will take you through the basic concept of why we should learn this subject, that why this study, what we mean by contract administration and law, and what is better administration means better management. We have to understand with the difference between administration and management. We are always usually, we as an engineer on the work site, we consider administration as a management and management as a administration. So, and we have never thought of any of our activity with respect to the law of the land and why law of the land is required to be known to us. What is the reason? The question is, should engineer or professional need to know laws governing their activity? That is a one question. And then the answer I was trying to fathom out is that it is to mitigate or reduce damages being done through ignorance of law. See, most of our projects are not failing in engineering. Very rarely you will find that the projects are being failed due to engineering. Most of the time it is failing due to its execution process. Either it is delayed, or it is abandoned, or it is terminated, or it has gone for litigation. And all these aspects are coming out of the law. And we as an engineer are not having a basic knowledge of law, and that ignorance of law is creating problems. So we should learn this, that why answer is that we should learn this subject so that we can mitigate or reduce the damages being done to the project and to the organization, be it a contractor or employer. I'm not going to say either on the contractor side or on the employer side. What I will talk is that why as an engineer, why as a party involved in execution of the project should know the basic knowledge of law. And then if we as an engineer, if we look at this graph, you can see that intensity of our conflicts are started coming up towards the end of the project. Not in the starting, we are going with a very good node. We work together, we start the project with enthusiasm, but down the line, our intensity curve is becoming sharp. And when this intensity curve is becoming sharp, we start fighting with each other. We start doing allegation with each other without knowing that under the contract, what are my rights and what are my responsibility. I just go on blindly talking about some clauses of the contract without understanding how the law will look at those clauses, how law will read my contract, how the law will interpret this contract, how law will interpret the conduct of the parties. One thing we have to understand, that our construction contract is not a contract of point, that you go to some store, buy the piece, you pay the money, then you have a contract between the warranty and guarantee. It is a one item, but we don't have like that. Our construction contract, they are having a series of promises and series of reciprocal promises. Our every promise and every reciprocal promise depends on each other. Unless you give me the site, I can't start the work. Unless I carry out the survey, you cannot come and check my layout. Unless you give me the drawing and design, I cannot start the excavation. And like that, dependency and non-dependency activities are n number. And during the process of execution of this, somewhere we are missing that link. And when we are missing that link, we start with this conflict interest. And when we start with this conflict, the problems start happening. The question came to my mind when I was doing my research as a student, that why, if this is so the problem, why this subject is not introduced when we were learning in the college? Because I am a 1978 engineer. I did my engineering, or I started calling myself as an engineer in 1978. I have never heard of this. I, as an executive engineer of Government of India, never heard about so much about the claims and arbitrations. Yes, we were having a conflict of interest, but we were not passing from so much of stresses what today's construction industry is passing. Then I tried to thought at what our forefathers were doing. Then I started doing some research. Many of you may be aware about the Bombay, and look at this. Many of you know what is the municipal corporation building. Many of you know what is the High Court building. We are knowing what is the President Magistrate Court, PWD building. And look at it. This is a 19th century construction scenario. And look at it. All the projects have run into number of years. It has started from 3 years to 9 years. So we cannot say that because there was no delay, there was no disputes. Delay were there at that time also. Delay are there even today also. Our project, which is started with the 2 years completion period, we are completing in 6 years, 7 years, 10 years. We are having a problems. But why they were not having a problem? The answer is in last 2 columns. Estimated cost to actual cost was standstill. It was static. While we at today, with the system and with the development of technology, with the development of economical reforms, with the development of so many other problems, our cost is going haywire. Today, when I am bidding for the contract, my cement price may be 800 rupees. But when actually I open the first bag of cement, my cost of the cement might be 1,000 rupees. Whatever contingencies I provide into the contract, whatever may be the escalation given to me, I'm not able to meet my 2 hands. And we don't have inbuilt mechanism to cope up with this. Because our forefathers were not having this problem of estimated cost to actual cost, they were not having a dispute. So disputes are arising out of not from the differences and disputes or claim. It is arising because the contracting parties start losing. The moment they start losing, they want to find out from where they start earning. Now, does that mean that because we cannot handle the contract, we have a dispute? Does that mean that we have become litigant? Or does that mean because we mean no business but interested, not interested in development, when only in litigation? Ponder over it. Is it true that we are having dispute because of this point? And then my research, because I have done at that time the questionnaire survey, and all out of 100, 99 said the answer no. Then where is the problem? The problem is very simple. Our contract have become a complex. If you have seen those buildings which I was showing you earlier, Bombay, whichever the year they were in the year in the span of 20 years distance, but the technology was same. The same stone technology, the same type of structure, the same type of design. There was no much technological change. But today, technology is moving very fast. Today, when I call for the tender, and then by the time I reach to an end of the contract, whatever the provision I have provided may become absolute. And then the employer asks the contractor to provide the new technology. The moment you ask him to provide new technology, he will say, give me extra. Now there is no provision in the contract that how to give extra. Or sometimes, because one thing we have to understand in the government contract, because our construction industry, 90% of our budget is controlled by government. Government has their own system of handling the project. Government has their own allocated budget. If the technology change required them to put up a new cost, which increases the cost, sometimes they are not in position to provide us the budgeted provision. They tell the contractor, okay, you carry out, we'll look into this COS. COS means change of scope. We all know these are the new technology. In my days, we were knowing only the word was an extra item. Except extra item, we were not knowing all this word, change order, variation, negative variation, positive variations, all those, and debit note, all these things were not existing when I first passed my engineering and went into industry. But slowly we have to start learning that, because the technology changing, because the method of construction changing, because number of players are increasing. Previously in the building industry, hardly civil and electrical and plumber were involved. But now we are having a HVAC. Now we are having a camera people, so that the security systems are there. Now we are having an entry exit by the thumb or by your iCard. So that system is in getting included. So number of agencies involved in construction industry have increased tremendously. And we are not able to cope up with coordinating with every industry. The civil contractor will say, because of plumbing contractor, my waterproofing work is delayed. Plumbing contractor will say that because of the electrical contractor, my work is delayed. Plumbing contractor will say, because the contractor has not done plaster, I cannot have a niche, I cannot do the concealing. We have started, instead of finding the solution, tendency has gone into putting an allegation on each other. The teamwork concept is missing from our construction industry. So first of all, apart from law, we have to develop a teamwork. Once we have a partnering concept that let us work for the project, we work for ourselves, employer work for their organization, contractor works for their contracting company, plumbing contractor works for his plumbing contract. We don't look project as a whole. I look project only from the my concept only, and whatever is the my scope only. Instead of that, the first concept we have to develop is a partnering concept. Let us have a partnering, let us share the problem rather than putting an allegation on each other. So once we know that no, we mean serious business and all that thing, then where we are failing? Then we are failing. First is our conceptual failure, that we are not working for the project, but we are working for the organization. So first of all, we have to change our concept from individual to a project. And second thing, that we have to understand our contract from legal perspective, because at the end, when we will start fighting, or when we will start putting allegation on each other, or when I say that no, these are the claim, I must get it, then the law comes in picture. And when law comes in picture, we don't know what is law. And that is why we must know the law. Now, when I say we must know the law, the question arises, why should I? I'm an engineer, I'm doing my work. Why should I know law? For doing the legal work, advocates are there. So my concept for why you should know law is not the entire legal system. I don't say that you become advocate, but you should know the basic concept of the law. And that basic concept of the law, I have given a name as a first aid box. Like doctors, every organization of us are having a first aid box in their office. Why? Are we doctor, but still we keep it? If I have got little cut, or if I fell down, or if something immediately happens, before going to doctor, we try to keep the person who is injured into a comfortable position. And then we take to doctor, so that we know that the person who has suffered accident or a injury is safe, that the immediate protection is given to that person, whether he or she is getting that. And that is, we call it as a first aid box. When we say that is a first aid box, then you go to a professional. I don't say that you don't require advocate. I don't say that you don't require a person professionally trained in legal system. We require very much. What we require is that we have to provide him a tool or a documents by which he can understand our problem. The problem is that they don't understand our problem because we don't have anything. Every documentation is haywire. We don't have contract administration in a real perspective. I will explain you this problem with this example. See, these are the two awards, copy of two awards. Arbitrator given the award. In both the case, Director General CPWD retired was the arbitrator. Both the case, project was on the same compound. Out of 10 building, 5 building was given to one company, 5 building was given to another company. Same organization, that is Hudco. One was Sapurji Palanji, another was a Ahluwalia and partner. In both the case, Hudco was represented by one Mr. Kumar. In both the case, Sapurji Palanji and Ahluwalia, both were represented by Mr. Kirti Dave. Now he is no more, so I will say late Dr. Kirti Dave. Both the cases were been represented properly, both were identical, both were having same design, both were having the same contract. But what went wrong? Look at the result of the arbitration award. Look, the Sapurji Palanji got the money and look at the Ahluwalia got the money. Where they fail? Where Ahluwalia fails. In spite of that, in both the places, same person was arbitrator. In both cases, everything was identical, but in Sapurji Palanji, during the execution of construction work, they have administered the contract. So we have to understand what we mean by administering the contract. Administering the contract that you reach at certain point in the during execution. At that time, your certain rights are coming to an existence arising out of the contract. Or some of your rights are being curtailed through the contract. And then at that time, you have to put up your correspondence in a manner to protect your rights. In this contract, it was written that delay damages claim cannot be referred to arbitrator. So there was an exclusion. It was an accepted matter. It cannot be referred to arbitration. When the project got delayed, Sapurji Palanji says that give us extension with our right to refer the claim with the arbitrator. Hudco said no. We said in that case, we are not taking up your extension. Now here where the law is coming in picture. Can the contractor refuse to accept the extension? Law says yes. Because our contract are governed by Indian Contract Act 1872. Indian Contract Act 1872 says that under section 62, that addition, alteration, novation, change, anything about the contract can be done only with the consent of both the parties to the contract. Can owner unilaterally extend the contract? We all have that concept. Owner ne de diya, hum kya karenge? What can we do? Yes, you can refuse. And that is what Sapurji did. Sapurji says, if you are giving us extension with provision of LD, without my right to refer the delay damages to arbitrator, thank you very much. I am going out of the site. I don't want your extension. Because extension of time is a change of contract, novation of contract. And that can be done only by consent of both the parties. That legal knowledge was available with Sapurji Palanji. That knowledge and that administration was not done by Ahluwalia. So what has happened? Finally, Hudco told Sapurji that, okay, we will allow you to refer all your claims to arbitrator. Please complete the work. There was a MOU signed between both the parties. Work was completed, matter went for arbitration. Ahluwalia also went for arbitration. Both were Director General CPWD was appointed as arbitrator, but the result is different because their arbitrator was restricted not to refer delay damages and other claims to them. Even their associated nominated contractors' claim were not permitted. And look at the Sapurji Palanji's award. This is where contract administration is required with the knowledge of law. Sapurji could do it because they were having a knowledge of law that under Indian Contract Act, employer cannot force me to accept the extension they are giving. If they reserve the right for LD, I have equal right to reserve for my claim. They cannot say no, 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 no. But unfortunately, that is happening. That is happening in today's world. That when we are going there, what employer are saying, unless you give us no claim certificate, we will not pay you. If you insist on not giving me the no claim certificate, we will encash your bank guarantee. See, this is nothing but, though I'm using little harsh word, I will say it is nothing but a blackmailing by the employer. Because we have huge amount of our money lying with them by way of retention money, by way of unpaid bill, by way of my bank guarantees. Sometimes they confiscate, NHI confiscate your huge crores of worth rupees of machineries, your resources. So they mandate it, they write no claim certificate. Now here where you required contract administration, should I give no claim certificate? I have no choice. What you will do it? Simply first write a letter to the organization, sir, why are you asking no claim? I have a huge loss incurred because of no fault of mine. So engineer will say, no, nothing doing, you will have to give no claim. Then you say, sir, can you give me the draft of no claim certificate, which draft you want? Then they will say, no, will not give you, you know what it is, give it. Then say that, sir, okay, as you have insisted, we are giving you this no claim certificate. Then they will say, no, remove this insistence. So you say, okay, we hereby unconditionally give no claim certificate. What happens? The law says this amount of correspondence is nothing but the coercion, the undue influence, the pressurization on me, and court will call it this no claim certificate as void, not enforceable under the contract. And that is what you have to do. I have got it successfully done so many things. The biggest judgment for this no claim certificate is Associated Construction versus Pawan Hans. Associated Construction was told by Pawan Hans that unless you give no claim certificate, we will not pay you anything. Associated wrote such type of letter, then went for arbitration. Arbitrator says accepted, because arbitrator was a judge. He accepted that yes, this no claim certificate is not enforceable under law. It is a void, and hence he has awarded the work. Matter went up to Supreme Court. And what happened? Supreme Court says the arbitrator is right in declaring no claim certificate as a void ab initio. That is where the law works. Because we should have a knowledge that I can get it declared certain thing as a void even if it is forced upon me. But for that, you have to administer the contract, you have to write the correspondence tactfully, you have to do so many things systematically. And that is where the contract administration role comes. But merely writing letter without knowledge of law will not help you. And for that purpose, as a first aid box, you must know certain minimum legal requirement related to our construction industry. Rest, our professional legal fraternity will help us out. If we provide this tool to them, then they will can bail us out from this problem. And that is what has happened in this Sapurji Palanji and Aluwalia case. There is another example I will show you. You can see that who are the arbitrator. Two retired Chief Justice of Supreme Court. One is Supreme Court judge. This was the case with National Highway Authority versus one NKL contractor. Here, Kirti Dave was representing NHAI. Now, the mistake done by contractor was that they said that you give us bonus and you give us delay damages. Now, how both the things can go together? If you have completed the work earlier, then the project is not delayed. And if project is delayed, you are not entitled for the bonus. And that is where legally they got confused when we argued the case before these three arbitrators. And finally, in the confusion, I will say confusion because during the progress of arbitration thing, we have accepted certain his extra item work. But the confusion has gone so haywire that you can see that they have rejected all the claims of contractor. And here the contractor face under the law to prove their claim. And how they should have done, what they have done is a different issue, because for a given time, the entire law cannot be taught. But I'm trying to generate a curiosity in all of you that, okay, such type of things can happen. How I should handle my contract, what I should do. In this case, it has happened that NHI got the cost of arbitration from contractor. I think this must be the only case in NHI where NHI got the cost of arbitration and contractor got a zero claim. Another case, because I have, at some places, I will not give you the name, because I have signed with some of my client a non-disclosure agreement. So I cannot disclose their name. At that time, I will put either XYZ or ABC, or I just say NHI versus one of the contractor. Here I was representing contractor against the NHI, and I got the award of rupees 200 crore when 10% of the work was done by my contractor. And contract was terminated by NHI. They confiscated all the equipment, machinery, resources, everything by them. But we have, when we were on the project, when we were executing the work, our correspondence were in such a manner that some of the clauses we have nullified during the execution of work by writing a letter. Now, the question sometimes the contractor asks me when I generate or when I give such type of lecture, Madam, how can we start fighting from day one? We समुद्र में रह के मगरमच्छ से या तालाब में रह के मगरमच्छ से दुश्मनी हम नहीं कर सकते हैं. We have to work there. This is not the only project we have to do. We have our career, our entire existence is with them. How can we start fighting? Yes, we can't start fighting. What you are required is to write a full letters, between the lines letter. That, sir, please appreciate. I'm waiting for this. My machinery is here. When are you going to give me the site? When are you going to give me the drawing? I'm just recording the facts. I'm not day one saying that pay me the damages. I'm not telling on the one day I will charge you the extra money for this. You have to write very tactful letters, very systematic letter, which we did it in Sapurji Palanji. You have to do it. That is what we have done in this case also. And when we went to arbitration, all our correspondence were a justifiable legal evidence in the eyes of law. See, what we are lacking, why we are losing the case? We are losing the case because when we are producing certain document, they are not a justifiable document. Document should be justifiable in the eyes of the law. We can't go with our sentiments of as an engineer. Likha to tha. I have asked you, I have told you. But your telling does not mean that it is a justified document. It has to be written in some systematic way. There should be a course. I will recommend to CEAI that they should have a course mainly on how to do the correspondence, nothing else. And correspondence related to extra item, correspondence related to variation, correspondence related to non-availability of land, correspondence related to if you are not having a tree cutting permission, because our contract says tree cutting responsibility lies with contractor. What law says? I as a civilian, a civil person in the society does not have a right to cut the tree without the permission of the government. So who is the person who is in a superior knowledge and superior capacity? It is a government. Even if there is a clause into the contract, we have to write systematically, sir, yes, we will do the coordination, but your support is required. And then I can prove because of lack of support, I could not get tree cutting permission. Once I don't get tree cutting permission, what I did, that I could not carry out the work, and this delay is not attributable to me because though provision is there in the contract, liability is not with me. And that is how one has to do the correspondence. One has to learn that every situation, how the correspondence should be done. The another example I will show you. See, you have to keep this record. Look at Sapurji Palanji versus MSRTC, this Bombay-Pune Expressway. When first time it was constructed, one of the portion was with Sapurji Palanji. In the original period of construction drawing, hardly 29% of firm drawings were available, and only 71% was revised drawing. And if you can see here, in the extended period, 78% of the firm drawing were made available in the extended period. Now, we are engineers. If I go on talking, judges will not understand what I'm talking about. Drawing available, drawing not available, extended period, non-extended period. So we should take advantage of our profession. So what we did, we created this graphical presentation. We showed it to arbitrator. Of course, in this case, there was no arbitration, but Secretary MSRTC was there, who was a non-technical person. So we went with this presentation in a graphical manner, and anybody's eyes will get catch. So, oh, this is the position, how we can blame the contractor. I think somebody is talking, so I'm getting disturbance. Can they have a mute? Hello? I'm getting a lot of noise, please. Please mute yourself. I'm sorry, but because it's too much of noise in my ear coming. So another advantage we as an engineer is that we should use the tool of our graphical presentation. Wherever I am arbitrator and wherever there is a technical nature of claim, I always ask advocate that take help of engineer and do the graphical presentation. This is another way of contract administration, that we should keep all this record and drawing register. In one of the arbitration where I was the sole arbitrator, I said, the advocate started arguing that drawings were not made available. I said, this is your statement. Where is the evidence? They says, madam, there was a register. I said, okay, produce the register. It is not traceable. I said, I can't believe just because you are saying not traceable. Some evidence must come to me. Sometimes we are facing in arbitration this type of situation also. So not only contract administration, how to keeping record properly in a systematic manner is another area we have to learn, apart from our engineering. I have seen in many arbitration, even though I as an engineer, I feel that yes, contractor must have suffered on this case. But in lack of evidence, I can't award him. And I have not awarded. This is because we are not, but here you can see this case was settled outside the arbitration. Secretary says nothing doing, let us negotiate. And negotiated, they offer some amount, we insisted something, and in between it was negotiated and matter was closed. Similar thing here. Now I have started with talking about bonus and delay, both things. I have received the bonus in this case, even the contract was extended beyond the original period. I told the commissioner, this also was settled outside the arbitration, outside the litigation. We went with this and we said, sir, I would have completed my work. Look at the monthly progress report, all my machinery, all my resources, all my engineers were always available on site. What was not there? Look at this graph. Hardly 3% of drawings were made available in original period. How you expect me to complete the work? I wanted to complete the work. I wanted to earn the bonus. Now, if I say give me bonus, can they give me the bonus? No. What is the legal way out? It is a deprival of my earning the bonus by the organization, but not providing sufficient work front. Because it was my right under the contract to earn the bonus. I would have completed. You prove that I could not have completed. But I have proved that you were failure because you have given hardly 3% of the drawing during the original contract period. Then there was a negotiation went on. Then MSRTC says, we will give you bonus, forget about delay damages. Contractor said, fine. And matter was settled. He was paid the bonus. So this is what the documentation and contract administration is required. We know that contract administration is better than construction management. We are sometimes mixing these two, construction management and contract administration. Construction management is not contract administration. Construction management is to get the work done in qualitative manner. Construction management is to do that whatever the work is done is measured properly. It is certified properly. It is, if the rectification to certain extent is required, rectification is done properly. Whether the timely things are done or not, whether the adequate resources are available on the site or not. If you look at all our MPR, monthly progress report, it is nothing but construction management. But contract administration is that how you administer your contract document. Even if it is a one-sided contract document, during the progress of execution of work, by writing a letter, you can remove those clauses which are against you, which we did it in Sapochi, in Hudko case. Though the clause was there that delay damages will not be referred, during the extension of time, we said, don't remove that clause. So such type of thing is possible directly or indirectly. And as I told you, that for that one has to undergo how to write a letters. Because writing of letter is nothing but contract administration. Sometimes what we are doing, we are getting the letter, but we are not replying. After 1 month, 2 months, 3 months, we are replying. How much the law will look into that? Because down the line, I will show you certain legal doctrine. That legal doctrine will help you that your non-reply of your letter is detrimental to you. And both sides, sometimes contractor writing letter, employer is not replying. Then it is detrimental to employer. If employer writing the letter, contractor not replying, it is detrimental to contractor. So one thing we need to worry about contract administration more rather than construction management. I will give you with what can happen if you have ignorance of law. With some example, but without disclosing the actual name of a person. But these are all factual stories. One or another, or directly or indirectly, they were my client, or they were the party before me, I as an arbitrator. So there are certain things, as I told you, that I'm not allowed to disclose the name because that is a legal requirement. So I'm just telling one Mr. XYZ. That Mr. XYZ was MTech PhD from IIT Bombay. Now we think that once I am an engineer of a substantial standing in the industry, doing so many projects successfully, that is what we feel, that we have done so many projects successfully. We know how to write letter, we know how to write contract, we know how to read the contract. So this gentleman was having a 3,000 square feet of land with him. He entered into an agreement with one Mr. LMN on 100 rupees stamp paper. Now this concept also you should come out that everything written on stamp paper need not be enforceable under law. Sometimes the content makes a lot of difference. Sometimes law requirement is different. Now recently we have got the Supreme Court judgment. We are signing our contract agreement on 500 rupees stamp paper. And we are not registering the contract. Supreme Court says that if the contract is not registration, arbitration is void. You cannot go for arbitration. The contract itself they consider as a void. I have no problem if you give this judgment. What happens then? What happens that I have executed the work under that contract? How you deal with that? If there is no contract, if you declare that I have not registered the contract, you rectify it. But if you declare that contract is a void, What happens that all the performance I have carried out under that contract? Nobody answered us. And why this? Because the fraternity, that is our engineering fraternity, has not put up this question to the legal fraternity. And legal fraternity has not put up before the court. Our fraternity has to ask this question, that sab aap puchiye to sahi. If this contract is not existing, what happens the performance carried out by both the parties? What will happen to that? Where can I go? If contract is void, I can't go to even the court of law. What happens? We are not asking. We think that my contract signed on 500 stamp paper, it is done. No. Check out whether your contract is a valid contract. Sometimes that is what will happen with this Mr. XYZ. His lifetime earning. When he came to us that this is a contract, now you file a case against this person who has promised me to develop. We said, but there is no contract. Why? Because the consideration in the contract was missing. There was an agreement that Mr. XYZ will allow Mr. LMN to develop the land. That was the only agreement. But what happens? Under which money? Under which consideration? And the basic concept of law, Contract Act says, a contract comes to an existence if there is an agreement having a consideration in it. Then only it becomes a contract. Merely agreement are not a contract. They are not enforceable. They are saying it's agreement. I agreed. Okay, that's fine. So this document was an agreement. It was not a contract because the consideration was missing in this document. Even though he was MTech PhD, his concept about the basic law was not available with him. If I know contract required two elements, agreement and consideration, I will be careful. Like we are always talking about extra item. And we are thinking as a contractor that it is written into the contract that the owner can ask me to execute the extra item. Owner are of the impression that I have a right to demand for extra item. It's an agreement. Extra item clause by itself is a provision into the contract. It is not by itself is a contract. That in event, and then we have a provision in that extra item that in event we will carry out this extra item work, the rate for that extra item will be decided as per the following procedure. When we have everything, but we are talking only of execution and not talking of consideration, extra item is not by itself is a contract. I can refuse to execute extra item and owner cannot insist me or punish me for that. There is an entire law on extra items, variation, change order, variation in quantity, and all these clauses have a different legal interpretation. It has a different methodology of handling these clauses. What you do when you come across extra item. What you do if you come across a variation in quantity. What you do if the item is existing, but the content or specification of the items are changed. All these three has a different legal requirement and different legal method to handle this situation. So we have to understand all these things. The basic concept, agreement with consideration only can be said to be a contract. And this Mr. XYZ was having only an agreement, and all that years he was under impression that I am having a contract and I can sue this person in court of law. We said that you can't go to court. Court will ask you, where is the contract? Where is the consideration? And it was missing. Another example, sometimes what we write into the contract or we frame the clauses or we frame the BOQ in such a manner that we ourselves don't know what is the meaning of this. There was a contract between the employer government entity and a contractor regarding the soil improvement facility. This soil improvement was required to be carried out by stone column method. We all engineers, so we know what the stone column is. There are two methods of stone column. One is a conventional method where you dig out the hole, take out the soil, fill up with the metal, then pressurize it, put it, compact it, and improve it. Another is a dispensable shoe method wherein you don't take out the soil. You pressurize the soil so that they go and fit into the voids. Whatever the little hole is there, you fill up with the stone and then again compact it. The government invited the tender, BOQ item number 1. A, conventional shoe method, conventional method 700 mm dia, or B, dispensable shoe method 500 mm dia. No problem, because they were not sure which method they want to use. So they put or. The mistake they did, they put one quantity and one rate. Contract tender was invited, contract was awarded. Contractor started doing the work with dispensable shoe method. That is 500 mm dia. Government said, no, we don't want this. We want conventional method. He said, fine, but I have quoted for dispensable. If you want conventional, give me the different rate. They said, no, we have written a or. He said, no, or doesn't belong to you, or belongs to me. They said, how come? We have drafted tender. We have put up this or this, so or belongs to us. Here where the law comes, or belongs to whom? Matter went for arbitration. Retired Chief Justice of Supreme Court was the arbitrator. In the first meeting, this is the only arbitration I can say was completed in 4 hours time. Simply 4 hours time. He asked us, what is the matter? We said, we just want to know or belongs to whom. He said, why there is a or? There are 2 items, 2 rate, 2 quantity. We said, no, there is only 1 quantity and 1 rate. So or belongs to whom? Who will decide this rate is belong to which item? So he asked second question, who drafted the contract? We said corporation. Oh, then or belongs to contractor. Simple legal interpretation that if you create an ambiguity into the contract, the drafter of the contract has to suffer. And that contract, the award was given. Now here where our engineering is required to be provided help to the legal fraternity. Till then, there was no problem. It was a legal perfect interpretation. Then he asked that how you will quantify this claim from 500 to 700 mm dia. Contractor was represented by techno-legal person. So naturally, when you represent your party, naturally we try to protect or try to get extra advantage for our client. So he said, sir, D1 by D2, 500 mm dia to 700 mm dia. The opposite side, though government engineers were there, the legal person said, maybe, sir, maybe it is a D1 by D2, we don't know. The engineer kept mum, they said that why, and believe me, because sometimes we get a doubt that contractor must have purchased those engineers, so they kept mum. But that was not the case in this case. Engineers sometimes, where they have to speak, they feel shy of speaking. And the another thing I want to tell all engineers, don't feel shy of talking. If you feel that something which is related to your engineering background, tell your advocate or a counsel that, sir, please understand us, understand this. This is not D1 by D2, because there are certain things which is common to be removed. What is that? The overhead remains the same. The dig remains the same. What is the additional thing? His power required less as compared to dispensable shoe. What is the extra he is going to use? Only the quantity of stone. So only that much extra should be paid to him, and not in the ratio of D1 by D2, where my profit, my overhead, my resources, everything will go into that ratio. Which the claim which otherwise would have been 80,000 rupees was awarded for 80 lakhs rupees. Just because engineer could not speak. They got nervous. They got nervous on the first instance. Or we lost the case in or. Okay, you lost the case in or, but at least win in the quantum. But we don't argue on quantum sometimes. And if you don't argue on quantum, then this or case, legal interpretation was perfect. Quantum arrived was absolutely haywire. Against 80,000, they got the award of 80 lakhs rupees. So we have to be very, very careful when we are dealing with such type of cases. And this will give you encouragement that why we should learn this subject. I am here just to give you an insight that what is the importance of this subject. This subject can't be taught in 40 minutes. It requires number of lectures, number of sessions, number of so many things to learn this subject in detail. But this type of cases will give you encouragement to learn this subject. Then you will get, okay, let me learn what is this law. Another thing I will tell you, if you are doing LLB or you have done the LLB, does not mean that you are a perfect trained person. It is just a driving license to drive the car, does not mean you are a perfect driver. When we come out from engineering college, we are not a full-fledged perfect engineer. We slog a lot. We learn with our failure. We learn with our mistakes. And then we become a substantial engineer. So getting a degree does not mean that you have got a license to call yourself as a professional. You got a license to drive the car to become a professional. That is the difference. You have to keep it in your mind. So even if you have done LLB, don't be under impression that you know about the law. You have to learn the law related to our fraternity. What is Contract Act related to our industry? What are the legal doctrine? You have to learn what are the legal method of interpretation of contract. And then only you can say that, yes, I know little bit. I can make use my knowledge as a first aid box and giving the support to the litigant professional to win my case.
Excuse me.
Yes, sir.
Sir, ma'am, that time is a little short. Can you wrap it in a...
I will repeat it.
Yeah.
I will repeat it.
Okay.
I'll just, there are hardly 2 or 3 slides are left. I will repeat it.
Okay, no problem. Ma'am.
Okay,
Please.
okay, I will repeat it.
Go ahead, please.
Okay. Here also, the rebate was given by one company to the contract employer that if the entire project is given to us, we will give certain percentage of rebate. And during the execution, no work will be de-scoped from our scope. Down the line, some percentage of work was de-scoped. And they asked Mr. Y, senior executive, do you mind we de-scope this work? Under the stresses, under the process, we feel that, okay, jaane do, ye kaam nahi karna hai apne ko. And he said, gave one single line, we have no objection of de-scoping. If he would have put up a comma and put up subject to provision of the contract, he would have got his entire rebate back. But he has only put up a full stop. He has given a consent, he lost the rebate. Then there are certain legal doctrines you have to understand, waiver, estoppel, election. As I told you, if you don't answer the letter, it becomes a waiver. And once you waive your right, law will stop you to exercise your right, even if it exists into the contract. So remember this, that Ahluwalia lost their right when it has existed at the time of extension of time. Then they cannot go back and say, now you give me. No, U-turn is not permitted under the law. Then election, you have to select between 2, either to take the extension or say nothing doing. If once you elect, you cannot go back. And then alteration, as I told you in the starting only, that any alteration in the contract can be done only by consent of both the party. And that if you remember that, any alteration coming, write a strong letter but sweet letter. I don't say that write a letter with harsh language. You must write, thank you very much, sir. We appreciate your cooperation. We understand your problem, but please try to understand, and something like that. For that, you have to undergo a training of how to write a correspondence. Then there are certain implied terms. Sometimes we say where it is written that I have to do like this, or I have to follow the specification, or I have to follow the law of the land. They are implied. We have to understand that. that it is an implied condition. And the last of my slide is express term of the contract, that where if it is written what is time, money, everything, and how to interpret those. These are the 4 rules of interpretation. I will just in another 5 minutes explain you what this meaning are. Plain meaning rule means that whatever the makes the contract valid has to be taken. That or is a different thing. But if the contract is interpreted and they make the contract invalid, their interpretation will not be taken. This is the law. These are the rules of interpretation of contract under law. Then there is an express or unanimous rule. Sometimes we have a 2 or 3 bill of quantity. In one bill of quantity, if I write that it is including lead and lift, and one of the BOQ I miss out including lead and lift, it will be considered that additional lead and lift is to be paid in that, because if you express at one place, don't express at other place, it will be considered as deleted from that place. Then this etc., we write etc., adjudice generis. I say that L&T cement, Birla cement or etc., then I can bring any cement which can prove the same quality as of L&T and Birla. I cannot insist that bring only these 2 because you have written etc. That is called adjudice generis rule. And contra properentum, that if you create ambiguity, it will always be drafted, reinterpreted against the drafter, that or case. Government drafted the contract, they created ambiguity. Or belongs to whom? The ambiguity is there or belongs to the reader of the contract. And in most of the case, in our industry, reader is the contractor. So we have to understand this, and keeping this interpretation in mind, we have to read our contract document. Thank you very much. I try to generate the curiosity. I don't say I have taught you or I have imparted the knowledge. Difficult to impart the knowledge in short time, but I try to generate curiosity in you. Thank you very much.
Thank you, ma'am.
Thank you.
Thank you. Thank you for your enlightening and entertaining presentation on contract, construction contract and case laws. We appreciate you for your valuable time and give us enlightenment about legal dispute, contract, laws, and its usefulness in construction industry. Now, I like to speak about Ms. Ranjitha, who is our second speaker of this webinar series. She is an impressive academic record of having a master's in international construction, practice and law from prestigious University of Stuttgart, Germany. She also secured member of Royal Institution of Chartered Surveyor in UK, and she is recognized as a qualifier APC assessor, primary reviewer, and a counselor of RICS UK. She is a contract management professional specialized in claim, variation, delays analysis, and quantum analysis of construction contract. She is also a member of Association of Project Management UK, graduate member of Institution of Civil Engineers UK, and a member of Institution of Engineers India. After completing his assignment as a contract engineer for SMCC ITT Japan in a metro rail project, she is currently working as assistant general manager in Tata Project Limited. Now I ask Ms. Ranjitha to present his presentation on contract administration. Mr. Ranjitha, now floor is yours. Yeah.
Thank you, Asim, for your big words. So I will be sharing my screen. I hope I'm audible and my screen is visible to you.
Please.
Right? All right. Thank you.
I think little louder, Ranjitha.
Yeah, sure. Am I audible now?
Yeah, yes.
Yeah. So, good afternoon, all. I hope you must enjoyed the previous presentation done by Dr. Vandana Bhatt. It was very much interesting, and so I hope you have enjoyed it. So normally for this kind of presentation, Such an institute expects some people, around 10 to 15% of participants will not be an expert in such field. So I have been asked to take you through some basics idea of this contract administration. So today I will be going through the basics of contract administration. And I will be talking about the important terms and definitions such as contract, what is contract, and what is contract management, what is contract administration, and what is a contract administrator. So as you know, and as Dr. Bhatt said, the contract, as you know, like the contract is an agreement executed between the parties. And as you see in the slide, it says that contract, the Indian Contract Act says it's an document agreeable, enforceable by law. So, you know, there are a lot of contracts available in the field like employment contract, service contract, supply contract, etc. So for this session, I will be focusing only on the administration of construction contracts. I hope it's clear for you.
Yeah, Ranjitha, please go ahead. Thanks.
So, yeah, so just to commence with the content, I will be just going through all the listed type of contracts available. Maybe you must have worked with one or more of it, and you came across in your profession. So what is contract responsibilities? That is the basic idea of a contract. Like as I said earlier, the contract is an agreement between parties. So that agreement will be having a lot of information or obligations what the party has to do during the execution of a contract. The basic principle is that the both parties has to comply with those documents or specification or whatever written in the contract. So in short, the contract covers all the project deliverables. Why I have chosen the word compliance means the moment any party does not comply to any of this requirement, the dispute or differences starts. That as rightly that doctor said, it is like initially there will be having some period, there is no difference or disputes. So later stage when the parties has comments, they forget about their obligations, the dispute starts. So what is a contract management or a contract administration? So this is what in earlier slide also she was explaining. People have often think that this contract administration is the work done prior to signing of any agreement. But that is not true. Every contract starts at the date of signing its agreement. So the administration of such contract is very important. If you see the FIDIC, what FIDIC says about the contract administration, the works, there will be multiple contracts in a project. All the contract has to be administered in a proper way so that we can ensure that successful completion of any project and to minimize to some extent the disputes. So if you go through the big projects or EPC contract, there will be design contracts or construction contracts or whatever it is, but those has to be administered separately. So who is a contract administrator? So as we know, like a contract administrator is a person or entity who is appointed to administer any contract. So if you see the FIDIC term, FIDIC engineer or NEC's project manager or JCT's contract administrator, all means same only. So these parties are appointed to administer those construction contracts. So when we come to the Indian scenario, mostly the employers will be acting as a contract administrator, or they will be appointing a project management consultant. So they will be acting on behalf of the employer. So this, when they appoint a project management consultant, they will be always acting on behalf of the employer. So this will be a win-win solution situation, and they will be always biased with the employer when it comes for a decision making. So accordingly, if we see the what FIDIC Code of Ethics says, this contract administrator should be an independent third party neutral, so that we can ensure that this party is not biased with any of the employer or contractor. So why the contract need to be administered? This is the first question in my presentation. Why we need to talk about the contract administration, or why we need to administer it? So it is often says that for a decision making, while administering a contract, there will be a lot of situation happens. We need a proper decision or instruction timely needed. So for enabling that, it should be administered properly. And whatever the decision or determination you are providing, it should be ensured that this is impartial and fair to both the parties. And he can, means while administering the contract, if you are administering in a proper way, you can minimize the dispute in such up to some percentage at least. So as I said, so as I said in my earlier slide, like why we need an contract administrator to be independent. So if the administrator is independent, so we can ensure that he is not biased with any of the employer or employer's decision. So he can demonstrate that he is fair and reasonable in his decisions, and he will be having a clear idea about how can we manage a project in a better way. He will be having a proper resources, skilled resources who will know how to administer each phase of the project. So this is why we need an independent administrator. So in continuation, I'm just showing the organogram of a FIDIC. So if you see, you can clearly understand there is a contractual relationship between employer and the contractor. And for administering those relationship, we need a third party. This is how their basic idea of become a contract administrator as independent. If for a design consultants are there, maybe other consultants will be there, contractor will be there. So an independent party will be administering all the contract between the owner. So what is to be administered? This is my second question, like what we need to administer. So we have the project. It is to be important for the contract administrator to comprehend the project life cycle. What are the phases coming in a project, or whatever the phases he need to administer, and what is his scope and responsibilities, and he has to identify all the core clauses or critical issues. He has to list out all the upcoming risks. He has to make a risk register, and he has to monitor it properly, and he has to prepare a contract administration plan based on all these listed issues or whatever it is, and how he will be administering it in case of a claim comes. So these are the things to be mainly administering. So whatever I am talking about in situation, there may be a contractor's perspective and employer's perspective, but I will be focusing only on the contract administrator perspective, because it will be, it is a big topic. So I need to narrow it down to some perspective. So I will be focusing on this contract administrator's perspective. So hope I am clear on this matter. Right? All right.
Yeah, let's go ahead.
Yeah. So this is a holistic approach of a project life cycle. So if the contract administrator is already appointed from the inception stage, he need to administer the pre-contract, contract construction stage and post-completion stage. Since I am talking only about the contract construction contract, so I am limiting my thing to this construction contract. So I will go into detail in the forthcoming slide. So pre-contract, these are the activities basically he need to administer, like whatever the design coming or RFP tender floating or negotiations, approvals, budget preparation. These are the things he need to administer when he is assigned for a pre-contract administration. So when the third party is appointed for a construction phase administration, he has to go through certain procedures, like he has to, once the contractor is appointed, he has to submit a lot of things like insurance or bank guarantees, etc. Then the construction stage starts, where his obligations start. The parties has to pay properly, and he has to adhere to the timeline, scope, everything. On completion, it will go for a verification, and then rectification stage will come, and finally the contract certificate, completion certificate will be issued. So these are the things which he need to be administered during a project life cycle. So what is the role and responsibilities of parties and the engineer? So basically, as we know, only the employer and the contractor will be a party to the contract, and engineer or contract administrator is a third party. So this, as you see, whatever in the slide, this is not a comprehensive list. So just to easy to explain, I just put the basic only the main points in here. So if you talk about the employer's responsibility, so basically he has to hand over the site to the contractor, and he has to pay on time. Balance everything will be coming under contractor. If an EPC contractor, he has to design, otherwise he don't need to design, he has to construct, he has to oblige to the contractual terms, everything. So then, apart from this, what are the other responsibilities? What the engineer will do? So he has to monitor it. These parties are complying with the obligations, whatever written in the contract. So if he is not complying, then he will be able to pressurize the employer or pressurize the contractor, and he can try to get it done in a proper way. So now I came into the typical constraints in a project. So as you see, the scope, time, and cost, these are the three major constraints which ensure the equilibrium of the contract during the signing of the contract. So the moment any of this constraint changes, the contract equilibrium itself will change. So one thing you have to note, that the quality and safety is not part of a constraint. These are the obligation. At any cost, he has to do it. Contractor has to ensure the quality and safety. But scope, time, or cost, that is the three major things which ensure the equilibrium of a contract. So I will explain you this in detail in my upcoming slides. So contract administration plan. So it is why we need a contract administration plan. So it is the basic idea is that we have to identify, the contract administrator has to identify all the critical clauses and requirements, and he has to take a like roadmap that how he is going to resolve each issues, how he is going to monitor all the phase of the project, and based on that he has to prepare a proper contract management plan. So based on this plan, there will be certain timelines for each and every activities. For example, meeting frequencies or minutes circulation time, the contract notices, like issuance of notices, or like some method statement, how when the engineer has to review and respond, or how many days contractor has to submit his deliverables, etc. So, and finally he has to close it out. So then type of claims in a project. So whatever, as I said previously, these are also not a comprehensive list. I just mentioned few of the type of claims so that it is easy for me to explain to you. So there are actually under the contract, we can prepare only 3 types of claims under the contract. One is like employer making claim against contractor, and the other one is contractor is making claim against the employer. So when the employer, when it makes like if the contractor is failed for his time, or he is failed to comply with the quality procedures or scope, something like that, employer can make a claim against contractor. At the same time, like if the employer is making any issues, like he is not paying on time, or he is not giving possession on time, so those items, then he is not giving permit or final account on time, the contractor is able to make claims. But apart from these issues, there are one more point, like when, as I said earlier, the triple constraints, when some of the constraint changes, the equilibrium of the contract also changes. So for re-establishing that, there are certain claims to be made. So such claims, for example, the unforeseeable physical condition, or adverse climatic condition, or force majeure happens. So these times, it is not a control in the parties. It's not beyond the control of parties. So accordingly, to re-establish the contract equilibrium, there are certain claims need to be generated. Apart from these contractual claims, the only option is the tort claims. Though this is generally the parties will not be able to claim under the tort apart from the exceptional cases. So accordingly, these are the claims needed for a third party. So I am not going to discuss much about this tort. So how to administer? So in the previous slides, I was talking about what is contract administration and why we need to administer. So I am just going to my third question, how to administer it. So basically, the contract administrator should not memorize any clauses or provision in the contract. When an issue comes, he should relate that issue into the contract documents or the clauses. So basic idea is that a good contract should have all the answers for whatever the issues coming in a construction project. That is why always everyone try to insist as to use in the national standard forms, because whatever the issues coming at site, we can relate it to the clauses. All the answers will be available in the contract. And when it is to be ensured that when we give a like notice or determination or communication, we should always refer to such clauses that can corroborate the issues whatever happened at site, so that we can ensure that at later stage also the merit of the claim will sustain. So how we administer is basically the effective communication is the key to any of the contract administration. So he has to ensure that the contract communications are happening timely and effectively. He can prepare the project directory or escalation metrics. We should give the clear idea of like SPOC in a contract, and whatever the RFIs or letters he is issuing with proper clarity, and all the meetings are conducted on time and with the timely issuance of agendas or minutes, and reports, various reports, progress report. He has to be ensured that all the issues are, all the progress is covered and given on frequencies, whatever mentioned in the contract. And he should be tracking all the email communication, all the contractual notices should be coming on timely. So this is the main key. The effective communication is always the key of the contract administration. So I have listed some scenarios here. So what I came across in my professional career, and I would like to explain you how we have done these such situations when we came across. So first situation is like a possession of site. There was a highway contract of 50 kilometers, and during the possession of the site, the 5 kilometer was not available to the contractor, and contractor submitted a claim for extension of time. So how we can administer this scenario? Anyone? Maybe chat or something? It's not possible. Okay, I'll explain that. So basic idea is we have to identify what are the timelines given for each section, or is there any sectional completion available, and this 5 kilometer is coming on the critical path of that completion date. If not found, this is irrelevant, then we have to dismiss the claim. So while dismissing the claim, we should mention that this is not needed for completion of, this is not coming in a critical path. This 5 kilometer is not coming in a critical path. So based on these clauses, we are just diminishing the claim. So variation. So variation as per the, I just wanted to take one refer the standard from this. So I just used only FIDIC here, FIDIC Red Book here. As per the FIDIC Red Book, the variation can be a change in quantity or quality or sequence of any work. So there is a scenario for variation. So in a bridge contract, the design sequence stipulated is the construction of a main central span to progress either ends. So for reasons attributable to the employer, the engineer had instructed the contractor to carry out the works from one end to the other. So does it constitute a variation, and why, and how we will administer this? This is a clear indication of variation because the engineer instructed to change the sequence of works. So sequence of work, if the contractor changes the work sequence, then he will be losing his, he has to do a lot of rearrangement in terms of temporary works and post-tensioning works, etc. So this is a clear variation, and engineer has to issue the variation. So then I came to one definition of delays and disruption. So always this delays and disruption, people will be get confused of this delays and disruption. Delays are normally happen. Delays are a certain events which may delay the project. Sometimes there will be some time, there is always a time claim if eligible, but it's not necessary that we will always get a cost claim. Otherwise, there should be a like time related cost should incur by the contractor. But disruption is something different, which is like a loss of productivity of the contractor due to the employer delay event. So he is not able to do his works as he planned. So the moment we have to understand that the moment the contractor encounter disruption in his work, he start losing his money, his cost will go up. The important thing is like he will not be able to understand when he start losing due to the disruption. If you see this impressive figure from Derek Nelson, so he is trying to explain what are the disruption can happen in a construction project. It's hell lot of items are there. Anything will make the contractors lose his money. But if the contractor is not properly monitored, he has not planned properly, he will not be able to establish his disruption. Because if there is no plan, how he can establish that actually he lost his productivity. So I have some delay events I just listed out here. This is also again not a comprehensive list. So some variation, force majeure, and these are the common things. So since the construction projects are unique in nature and all the issues are also unique in nature, so anything can delay the projects. And I have a scenario here for the disruption. So there is a rail contract in that there was an finishing work has to be completed for the stations after the installation of heavy equipment. So the heavy equipment was to be installed by another contractor and he got delayed the works. So accordingly, the main contractor has not get proper work front, and accordingly he started reducing his productivity and he delayed the project. So how to administer this situation? Actually, when we talk about the disruption, we have to verify what is the contractor's planned productivity and how much he achieved and how much he delayed due to this particular employer delay event. And we have to ensure that the loss of productivity is not happening due to the contractors is on default. And sometimes the contractor will be undercoating, and later he will be coming up with a claim that his cost has incurred more. But we have to ensure that, and contractor has to prove that this adequacy of his contract sum, that he has adequately quoted the price the contract. So there was an interesting case in UK, like Water Lily versus Mr. and Mrs. Mackay. So it's a good, interesting read. In that case, the contractor has clearly proved the adequacy of his contract sum, and he could be able to establish that how much he lost his productivity and how much losses he incurred due to the disruption from the employer. This is actually a very difficult to prove such claims. So I came to the extension of time. So extension of time, as like earlier in the earlier presentation, Dr. Bhatt was telling, this is the extra time given to the contractor if if the delay even happened to the employer or something like that. So in that, this is an SCL delay disruption protocol, which says how we can calculate the extension of time. There are two methods, perspective and retrospective methods. So this is itself for a delay analysis, and we have to ensure that all the delays are happening on the critical path and something like that. Right? This itself is a very big subject and very interesting subject too. So I am not going into much detail of this. I just wanted to give it a basic idea, and I will be directly going into a scenario. So my first scenario to the EOT is there was in a contract where key date, schedule, and timeline for approval is stated. The contractor has submitted a claim for delay in issuance of drawing or approval. How to administer this scenario? So since the employer has to issue all the drawings or approvals on time, and it's clear indicated that he has failed. So, and the contractor is eligible for a time claim in this. And maybe if there is a time related cost, and he is eligible for that also. So my second scenario is, so in a contract being performed in a country wherein a seasonal rainfall disrupts a minimum of 90 days, and the contractor has submitted a claim for disruption or delays due to the adverse climatic conditions. So how to administer this? So when this adverse climatic condition comes, it is always here contractor has to prove that this is an exceptional climate considering all the 10 years data. He has to submit all the 10 years rainfall data and prove that this is an exceptional climate conditions. In such case, if he is able to prove that this is an adverse climate condition, then he is eligible for the extension of time. And sometimes cost also, but if it is considered under the force majeure, it's beyond the control of employer and he is not eligible for the time claims. So when I come to, I hope all the scenarios what I've explained here up to here was clear for you. So I have some 3-4 more scenarios. Is time allow me to explain all those?
Ranjitha, you can carry it on.
Okay, thank you.
No.
So this is my EPC contract wherein the preliminary design and the employer provided information is contractually defined as contractor's risk. How to administer a claim on unforeseeable physical condition at site. When it comes to an EPC contract, it is quite difficult to establish the contractor's position, because all the risk being transferred to the contractor through an EPC contract. That is the sole purpose of taking in an EPC contract. So if you still believe that you are entitled for such a claims due to not his own fault, and you are ensuring that your claim is credible, and you are not able to make the contractually validity, so then you have to take it up. So though it is very difficult, at some point, maybe at legal recourse, you may able to get it. So my next scenario is like in a contract, the contractor's progress has not been satisfactory and the engineer had issued notice to expedite the progress. So during this delay event, the employer had varied the scope. How to administer this? In such cases, we have to understand there are 2 or 3 methods how to calculate the delay. So in maybe if I explain 1 or 2, like we have to calculate the net delay by how much the contractor is delayed and how much the employer is delayed. So the next after the concurrency period, so contractor is eligible for that. Otherwise, how we can do is like we have to directly apply the liquidated damages of the contractor, and whatever the employer is delayed, we have to pay them back. So this is the way it's normally administered such scenarios. So and the next one is like a contractor has experienced disruptions predominantly not on activities in critical path. How to administer this? So if the contractor is not facing any disruption on critical path, he is not eligible to get any of the delay extension. So such claims cannot be entertained. So my next one is like pandemic and force majeure. So as we know, like pandemic is not written anywhere in the contract, and that will be dealt with how the government is providing. Like in India, I think they have given some 6 months of extension of time. So that's the way it will work. But when it comes to force majeure, it is not a employer, means it's not in hand of both the parties. So in such case, the contractor is eligible for the time, but not cost. And the final one in EOT. So which are the circumstances that entitle the contractor to suspend the progress or terminate the contract? So contractor can terminate only or suspend or terminate at only one situation wherein he is not paid on time. He can easily terminate the contract. So dispute mechanisms, whatever available in the standard forms, and the basically in our widely options available for alternative disputes. If you don't want to go to legal disputes, this is the best option. We should mention one or two from these ADRs available in our contract, so that we don't need to take a long-term dispute resolution. As per FIDIC, they provide the option engineer can provide determination within 42 days of the dispute is referred. If he's failed, we have to refer it to DAB, and he will be giving his result in within 84 days. And if not, we have to refer it to arbitration. And arbitration will be taking minimum 18 months, I think. And if not, then we'll go for a legal recourse. So similarly, NEC is also having mandatory adjudication and option for DAB or arbitration. So generally, in our professional world, these are the options available: disputes, boards, negotiator can be done, or mediation or conciliation, or expert determination, adjudication, and arbitration can be done before the legal recourse. It is only the point is that we have to ensure that we have covered this in our contract. So I just completed my session. Maybe it's a time for Q&A. So I'm just stop sharing my screen.
Thank you, Ranjitha, for your wonderful presentation of contract. I like to ask the participant to raise your hands for any questions, because due to some technical issue, the Zoom platform don't have the chat box. So we can't have the Q&A from the chat box. Any questions? Please ask here. Or if not possible, the participants can send their questions on the following mail, and we were happy to answer those questions as soon as possible. So please write down the mail. If you have any query regarding the webinar, you can just mail your query on the following mail.
Until no hand has been raised, maybe that we go ahead.
Okay, sir. So I request Mr. Sudhir Dhawanji to give his closing remarks on the today's webinar.
One hand is there.
Okay, one hand is there. Sir, one hand is there.
Thank you, Nair and Asim for organizing this.
Sudhir sir, 1 second. There's 2 hands were raised. I like.
Okay.
Yeah.
Sure.
The secretariat can.
Yeah. Just
open the audio so they can ask their questions. I'm asking him to unmute. He's not unmuting.
Mr. Samir?
Yeah, Samir. Samir, please.
Please unmute yourself and ask your question. Yeah, please ask.
Good evening, everyone. I just want to know from Vandana ma'am that like a guidance from her that in case if there are multiple contractors are working on a project site, and if input of one is to be considered as it means the equipment input is required for design of like foundation and all for this, and equipment supplier has to give the inputs. And if there is any discrepancy, initially he has given in the contract that it is considered on that basis contract was made on his input, but later on the contractor came to know that it is a wrong design and it is changed. Then whether the claim on that contractor can be put, as other contractors will be claiming to the employer.
See, if the contract for all the contractor is by the employer,
Yes.
then the main contractor who is suffering because of the wrong design or wrong input by the other contractor, the main contractor has to ask the claim to the employer only. And then it is for the employer, between employer and other contractor, to find out who went wrong. Because you don't have a direct privity of contract with the other contractor. You are just doing the work based on the input given by that contractor.
But if I'm acting as an employer and
If you are an employer, then
yes,
you have to pass
two contractors.
You have two contractors. So whoever has done wrong, you raise the claim from that contractor by saying that because of your mistake, I am facing claim from other contractor. So you pass on the claim to him, but you cannot avoid claim raised by that other contractor who has suffered because of the wrong inputs.
Okay, so that is possible that we can raise a claim to the that claim which one passed by one raised by one contractor to the other contractor.
To the other contractor, you can say it is because of your default I have suffered this.
But there is no such provision in the contract. Then also we can go if there is any provision in the law.
The provision is the claim is arising out of the contract. My professional work was to provide you a proper data and professional work. If your performance is bad in terms of quality or in terms of providing the information or in terms of providing the design, if you fail, then you are bound to suffer the consequential damage arising out of the performance under the law.
Okay, but ma'am, if we'll say as per 74 of the Indian Contract Act, constitutional damages are not allowed. So we can go.
No, that LD provision is only for the purpose of delay.
Delay. Yes.
This is not the purpose of delay. This is a consequential damage arising out of the contract.
But
for the performance of the contract, not for the delay of the contract. There are two different things. One is delay for which employer is providing LD.
Okay.
But the other is work is not delayed, but your performance is bad. Bad quality, bad workmanship, bad information, bad design.
Okay, ma'am. So the consequential damages for the performance of the contract can be claimed. And consequential damages for the delay is not cannot be claimed.
No, delay is
profit
then
or
LD.
loss.
Then there is
that
a
is
LD
only the
for employer.
Yes. Okay.
Yes, ma'am.
I think the answer is okay. And now we can have the okay. And we can have another question.
Suhas Datta.
Yeah, Suhas Datta, can please ask your question. Hello.
Yeah, he is unmuted.
Suhas Datta, please ask your question. Sir, please open Vishal Saha. He can ask because Suhas Datta is not asking any question right now.
Yeah, okay.
Hello.
Yeah, Vishal Saha, you can ask your question.
Yeah, good evening all. My question is, in one of our agreement, the agreement is based on fitting. But how?
Your voice is not clear. Vishal, your voice is not clear.
Hello.
Yeah,
Am I audible now?
Yeah, please ask again.
Yeah. My question is that in one of our FIDIC agreement, change order clause is there. But how to deal with this variation or change order, but as methodology is not given, that the contract up to certain extent 25% or 10% we have to revise the rate after 10% of the BOQ quantity or that. It is not given. After that, after agreement is completed by both the party, employer and the contractor, employer issue one circular for the approved variation methodology by approving it their higher officials and make it a part of the contract. Is it a correct practice?
No, it cannot be permitted. Anything after signing the contract is not a part of contract. You can refuse to accept it. And as far as
Okay, because that
quantity
is the main
variation,
issue with us.
yeah, and as far as variation in quantity is concerned, if quantity is not mentioned into the contract, then Supreme Court has given a judgment in absence of any provision, plus minus 20% is a variation, legal variation.
Okay, thank you, ma'am.
Okay.
So Harshdat, do you have any questions? Are you audible? I think all the questions has been answered. So I'll ask Mr. Sudhir Ravanji for his closing remarks for today's webinar and appreciate the participants for their active involvement. Mr. Sudhir Ravanji, sir.
Thank you, Asim. I think it was very interesting to listen, and I've learned a lot of things. Dr. Vandana Bhatt was really, in a simple way, explained all aspects, and this is the way people will learn law. If it is a complicated issue, a lawyer is talking, then it's not easy to understand everything. So they use so many legal terms that we get lost, if we are not used to it. So Dr. Bhatt, thank you very much for your presentation. It was, I think, most of the young people on this must have enjoyed, and it's a great having you in CEAI. And I also know that you're going to be giving some lectures in our Bombay program in the days to come. So thank you for helping us. And
She's the main anchor there.
She's the main anchor. Okay, thank you. And I think we will need you in the future also. Ranjitha, you did a very good job of explaining the various definitions and also explaining the theoretical part of the contract administration, and then linking those with scenarios. I think this was another way of presenting things. So both the methods were very, very useful. I would like to thank Mihir and Asim for organizing this webinar. It was a great show, and a lot of people attended. I have a few messages. One is that all the young professionals should consider joining CEAI. We have a special forum for you, and we have a special place for you in our various committees and also in the Governing Council. Another announcement is that we are organizing FIDIC training on FIDIC conditions of contract, end of August. This will be done by a trainer from London, Tanner, and Rajiv will announce this in the mails in the coming days. So any of you would like to join, please do join.
So date should be September 4th to September 9th.
September 4th to September 9th. Sorry, not end of August, but September 4th to 9th. We are going to do this not only in Delhi, but we are also planning to do in probably Mumbai or Hyderabad. So whoever is, wherever it is easy to join. Otherwise, you can join physically or online. Third announcement is that FIDIC Asia Pacific is one of the regional bodies of FIDIC. They will be having an annual conference in Bangkok from 26 to 28 November. And the topic is engineering towards net zero. And again, we have kept one session for young professionals. So Rajiv, we should send all this information to all the people who have attended today's webinar.
Okay.
And any of you who would like to present a paper during that program, during that conference in Bangkok. Please do send your abstracts, and we will see whether we can organize and to get your paper included. With these words, I think it is getting late, and my best wishes to all of you, and look forward to your active participation in CEI to raise the professional level. We need young professionals, and so we need all of you to take over from oldies like me and then run the CEI administration. Thank you very much.
Thank you very much, sir, for your kind words.
Thank you very much, sir.
Thank you, sir.
Thank you, sir.
Welcome,
With this,
welcome.
I close the session.
Yes, sir,
Okay.
please close the
Thank you.
session. Thank you all.